He says that the families of the victims are not grieving.
The person has been missing for at least 7 years without there. Anyone within the jurisdiction of Kenya can only be presumed to have been dead.
Already this petition seeks to quash the murder charges against the petitioner and the interested parties in criminal case number E019 of 2024. The contains, my lady, that proof of death is a prerequisite requirement that the DPP must satisfy himself before he can make a decision on decision to charge. Barring proof of death, my lady, the petitioner contends that the decision to charge is in error and therefore has a right to move this court to question the rationale for decision to charge. And if this court is persuaded, as we intend to do so, that the decision to charge was arbitrary, oppressive, and against public policy, then this court has an obligation under Article 165, Sub-Article 3, Paragraph D, Item number 2, to intervene and interfere with that decision. Clear, express, and unambiguous that we are protesting that you don't have direct evidence, you don't have circumstantial evidence that could prima facie support the fact that these victims are dead.
This petition raises two issues that we'll invite the court to make a determination on. The first issue is whether the decision to charge the petitioner and the interested parties with murder charges in High Court Criminal Case number E019 of 2024 was made in error, in bad faith, and contrary to the law. And the other issue that we find coming out in the petition, and indeed in the submissions by the IP and the petitioner, is whether the petitioner, together with the IPs, can be charged for the offense of murder without a certificate of death.
This court is being abused by the ODPP by subjecting the petitioner and the IPs to double jeopardy, which was clearly explained in the Republic versus Director of Public Prosecution and others, ex parte where Patrick Ogola Onyango and others in 2016 EKLR. My lady, why do we say there is an abuse of the court process? We say that means that the intent to charge was premature, as there has been no circumstantial evidence on death presented since this circumstantial evidence can only be weighed to conclusion of a death by a trial court through hearing of an application brought pursuant to Section 118A of the Evidence Act, which has not been extensively explored.